Hey, what's up, guys? It's Travis Britt with SOSPrep.com. What is SOS Prep? SOSPrep.com is a website where you get all your resources for the statewide officer certification exam. Whether you're in a basic recruit training program or you're looking to transfer your law enforcement certification from out of state to the beautiful state of Florida. What exactly is it? It's over 20 hours of direct instruction, just like these videos. And at the end of it, you're going to get a practice test just like the one we're looking at here. This is the actual random practice test that you're going to get. Thousands of questions. They're going to give you a random 200, just like you're going to face at Pearson View, right? So the game's set up just like the one you're going to have to play in real life. And I've been getting a lot of folks that are coming to me and saying, hey, the averages that I got on that practice test are exactly what I sat down and got when I sat at Pearson View. So it's a very good gauge to let you know whether or not you are ready to go and sit down for this test. Because I'm going to tell you guys, it's a lot cheaper, for one, to buy this product than it is to take the SOS 2 or 3 times, and not to even mention the mental stress and the fortitude that it would take, that if you strike out 1 time or 2 times, or God forbid 3 times, you have to go back to an academy. Like, not trying to push you guys on fear base, and you don't have to buy my products, but make sure you have a plan to pass this test on the first attempt. Do not take this test more than 1 time. All right. If it takes you 6 months to prepare for it, take the 6 months and knock it out. It's not worth the trouble and the hassle, because your anxiety is going to go up 50% every time that you fail this test. So let's pass it on the first time, right? So check me out, SOSPrep.com. If you can't afford any subscriptions, I've got guided notes over there as well. 17 pages of free guided notes. You can use your books and pass. I don't need your money for it. I want to help you out. So with that being said, question 200. According to Illinois versus Wardlow, the United States Supreme Court ruled what? This is a very good case to illustrate the difficulty of being a law enforcement officer, right? This case nails down how confusing making a decision as a police officer can be from time to time, right? And the courts, we talked about objective reasonableness and how hindsight's not 20/20 as far as objective reasonableness goes, and like they have to look at it through the perspective of the police officer that's on the street, the boots on the ground. But you're making split-second decisions, right, where your life is at risk. You are faced with peril, and the decisions that you make could be the deciding factor on whether or not you go home at the end of your shift, right? So it's tough, right? But on the other end of the scales, right, where we're trying to balance out justice, are constitutional rights, which in my opinion are more important than our lives, right? Constitutional rights are absolutely paramount, right? So you have to respect the Constitution, right? And I didn't mean that like your life doesn't matter, but the Constitution is what makes America America. You have to pay homage to that, right? So with that being said, according to Illinois versus Wardlow, the United States Supreme Court ruled what? It says A, that a person should be afforded the right to counsel should they be proved indigent, which is a fancy word for being broke, and that the state has a duty to provide a counsel should it not be possible otherwise. So that's basically saying, hey, they've gotten in trouble or they've got themselves hemmed up, right? Maybe they're even innocent, right? Because they're innocent until proven guilty. And they don't have any money for counsel, right? An attorney, right? Anybody to represent their side of the story in the courtroom. What should happen in that case, right? They're going to be provided an attorney, as you have heard, whenever you read the Miranda warning. Miranda versus Arizona is where that come from. And then there was another case in 1963, Gideon versus Wainwright in Florida, where an individual didn't have any money to provide counsel, and they told him, tough luck, dude, that's on you. It's not our job to provide you counsel. He wrote the United States Supreme Court, and they were like, yeah, you do, right? It's in the Constitution. It's due process rights. It's protected under the 6th Amendment, right? So you should have provided it for him, right? So that's Gideon versus Wainwright with a hint of Miranda versus Arizona. So I'm going to scratch that one because I know it's not Illinois versus Wardlow. And these are test-taking strategies. We scratch what we can, because now I've scratched one off the board. So what do I have, guys? If I just randomly guess a 3, if I scratch correctly, I've got a 75% chance of getting this right. So our odds go up every time we can scratch one off the board. So feel good about scratching them off the board. B says that a person shall never be compelled or coerced to self-incriminate without first comprehending and waiving rights afforded in the 5th Amendment. The 5th Amendment. The 5th Amendment. Do not have to self-incriminate, right? Eminent domain, no double jeopardy. The 5th Amendment, right? So I know what this case is as well. We just talked about it up top. This is going to be Miranda versus Arizona. Ernesto Miranda out in Arizona, low IQ, was interrogated for an extremely long period of time. Didn't feel like he was going to be free to go until he told on himself. They locked him up, right? Some pretty heinous crimes too, right? Some felonious crimes. So with that being said, you get the case Miranda versus Arizona, where they're like, hey, you have to make sure these individuals understand that they are protected in the Constitution. They don't have to tell on themselves they don't want to, right? So they have to waive their right to counsel, waive their right to not self-incriminate, so on and so forth. We know that's Miranda versus Arizona. I'm going to scratch that one as well, right? This is exactly what we want to do on the test. If I can narrow it down to a 50% chance, right, and I'm flipping coins on this test, I'm going to be good, right? So I feel really good about this question so far. C says, students who do not disrupt the learning environment must be afforded the opportunity to express themselves reasonably under the First Amendment. We got a First Amendment case, right? And I know for a fact that this one's going to be Tinker versus Des Moines, right? What happened with Tinker versus Des Moines? Some students wanted to protest the Vietnam War. They put some peace armbands on their arms and went to school. Principal didn't like it. Principal told him to remove it or he's going to suspend them. And they were like, we're not bothering anybody. We just want to, peacefully protest this war. We're not disrupting the learning environment. But we feel like we should have freedom of speech in the schoolhouse. He suspended their butts, all right? But he regretted it later because they said that the First Amendment follows you into the schoolhouse regardless of age, all right? First Amendment follows you into the schoolhouse, and as long as you don't disrupt the learning environment, then you can express your freedom of speech, right? So with that being said, what are some examples that would disrupt the learning environment? What if they had a shirt that said, FUCK the war, all right? That would disrupt the learning environment, right? So they could be mandated to change that. And when I was a kid, you couldn't even dye your hair to go to school, right? Because they said that was disruption. And nowadays, the kids are running around with all kind of weird stuff going on in the classrooms. But it gives you an idea of how things kind of change over time, right? For good or bad, indifferent, right? I'm just saying things change. That's one variable that stays the same. Things are always changing, right? So we have to stay up on this change. But C is going to be Tinker versus Des Moines. So I've scratched that off the board as well. So I know I've got my right answer before I even read it. So let's read it. It says that location alone of a high crime area is not grounds for particularized and reasonable suspicion, but also officers are not required to ignore relevant characteristics of a location that's in question, right? So let me give you the beans and bullets on Illinois versus Wardlow. Excuse me, guys. I got some allergies going on. Illinois versus Wardlow was a case that happened in Chicago. Wardlow was on the street, so it was a caravan of police officers riding around 4 cop cars, right? It's a jump out boys, right? They were doing what we used to call back in the ATL Thunder Run, right? You're riding through the projects and everybody scatters because they know it's the cars that are about to jump out and start Terry frisking individuals that are in an open air market for narcotics, right? So not condoning that, right? You need to be able to articulate all of your actions, right? You need to be able to articulate all your actions, but that's what this case sounded like to me. It sounded like a thunder run. They were riding through 4 deep, and they were just trying to shake the bushes and see if something would fly out. Individual Wardlow was standing on the street. He noticed the cop cars, headlong flight, bam, took off running, right? They gave chase, right? When they caught up to him, what did they do? They did a Terry frisk. Now, what's required for a Terry frisk? Reasonable articulable suspicion, right? You need to be able to articulate that the individual was armed and dangerous at the time of the frisk, right? What is it? Outer clothing, outer clothing, outer clothing. It's a quick cursory frisk. What are we looking for? We're looking for weapons, right? Can we recover anything else? You tell me. If it's immediately recognizable. If it's immediately recognizable. If it's immediately recognizable. Right? But this is not a search. We're not skirting the Fourth Amendment with this. It's not a search, right? So with that being said, they did their Terry frisk because they felt like they could articulate reasonable articulable suspicion, right, to stop the individual in the first place. So he was detained, right, to confirm or deny that there was criminal activity afoot. What did they do? They did their Terry frisk and they felt a weapon or immediately in a bag that he was holding, right? So they recovered that weapon. Come to find out, Wardlow was a convicted felon, right? So now we got to face 5, right? Convicted felon with a firearm. He's looking at some very serious trouble, right? Very serious trouble. So with that being said, they arrested him, right? He goes to the courts and he argues, or his defense attorney argues that there was no grounds for the stop, right? That he's free and under the Fourth Amendment, no unreasonable search and seizure. He's free to go as he pleases, right? And there's nothing illegal to just take off running if you want to, right? He just felt like bursting out in a jog. He was exercising, right? And I'm just being a little silly right now. I don't know if that was the case, but their argument was that under the Fourth Amendment, it's not illegal to run. It's not suspicious to run, right? If they wanted to change their set and setting, then they were allowed to do so because they said that there was no obvious reasonable articulable suspicion other than being in the hood, right? Which they were. They were in a high crime area, open air market for narcotics, and then taking off running, right? And he was like, why can't I run? What if I was over in the rich part of town and I was running, I was taking a little jog? Would you stop them too for being suspicious, right? So this is an argument. We see how it goes, and it's a good argument, right? Are you just stopping people because they're running, right? Are you stopping people because they're in a certain neighborhood? Are you stopping people because they look a certain way, right? Are you stopping people because they're social, economic, demographic, so on and so forth, right? So it's a good question, right? And as a police officer, you always need to be aware of this, right? Put yourself in the perspective of the individuals that you're coming in contact with and say, hey, like, how would this make me feel, right? Would I feel like my Fourth Amendment was being violated, right? And that's going to help you articulate your actions, right? Because I don't care about your feelings, right, if I'm doing my job, right? So feelings are one thing, but if you put yourself in the perspective of the individuals that you're looking at, like I look back to me and I'm grateful that I didn't grow up in an urban environment. I grew up in a poor neighborhood, but I was out in the middle of the country. They had like one deputy covering all over town. We never came in contact with the police. Nobody really called the police. But if I was in an urban environment and had contact with the police constantly, several times a week in some of these neighborhoods that are extremely rough, that have jump out boys that are jumping out all day long, in these neighborhoods, you know, I would have got in trouble for sure because I was a dumbass kid, right? And I had stuff in my pockets I shouldn't have had at times. And I guarantee you that if I had, you know, a lot of contact with the police that was warranted or unwarranted, that I would have gotten in trouble eventually. So it bears the question of, do you get as much freedom as you can pay for? Right? If you live in a ritzy neighborhood, is there any threat that you're going to be jumped out on by the police? But I mean, there's circumstances that have nothing to do with the individual. If you're born in the projects, that doesn't mean you were born a bad person, right? I mean, there are several great people that are in the projects. They're just, you know, they're fighting poverty like a lot of Americans are, right? So the question, long story short, the question is, high crime areas, how do we establish what's reasonable articulable suspicion? And this case got overturned in Illinois, right? So he got convicted, right, at the lower courts. He appealed and won, and then it was confirmed at the Illinois Supreme Court. But it was pushed up to the United States Supreme Court, and it was a 5-4 decision, guys. So what that means is, like, the smartest judges in the land had a hard time with this case. So what does that mean to you as a police officer? You better make sure you understand how to articulate your actions if you're dealing with a case that is similar to this, right? So what did they say? The United States Supreme Court, a 5-4 decision, right? So that feels like it could have flipped and went anyway. They said that location alone of a high crime area is not grounds for particularized and reasonable suspicion. So what does that mean? If I'm riding through the project, I'm not just jumping out on any and everybody because I'm in the projects, right? And it's a high crime area. A lot of people have been shot there that year. A lot of drugs have been sold. I've seen a lot of hand-to-hands in open air. I know it's an open air market for this, that, and the other drug, right? I know that there's lots of contraband in this area. But it doesn't mean that just because we're in that area that the Fourth Amendment is bunk, right? And that there's less Fourth Amendment in that neighborhood than there is in the rich neighborhood across town, right? They're saying high crime area is not enough for particularized reasonable suspicion, but that officers are also not required to ignore relevant characteristics of the location in question. So what does that mean? If you're in an open air market, for drugs, individuals are showing guilt-laden factors like evasive action to avoid police, that is grounds for, you know, a reasonable articulable suspicion. And you know, what do I need for a Terry stop? I need to articulate two things, right? That they're reasonable articulable suspicion, which we just talked about. The evasive behavior was a reasonable articulable suspicion. And how do I get to the nexus or the connection of guns? I get to that nexus or connection of guns because I'm in an area where I know for a fact it's an open air market for narcotics, right? And I know for a fact if I was going to sell drugs in that corner, it's extremely dangerous, right? And the chances of me being robbed eventually are pretty much 100%, right? So am I going to stand out there without a weapon? No, right? So I know when I'm in an area, open air market for narcotics, that I'm also in an area that a lot of individuals are going to be armed, and they're not armed for the police. They're armed for other dope boys that are robbing them, right? Or these little kids running up and robbing them, right? So with that being said, right, the nexus is there, right? And can I articulate that? That's the question, right? You have to be able to articulate that, and you have to be able to articulate it constitutionally, right? You can't just say, yada, 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 so I did this, right? You have to be able to note, like, per this case, per that case, per this case, per these guilt latent behaviors that I witnessed, right? Reasonable articulable suspicion was there. Criminal activity was likely afoot. I was detaining for a period of 20 minutes to confirm or deny my suspicions, right? Individual did a security touch on his waist. I did a Terry frisk because I was concerned that they were armed and dangerous at the time of contact, right? I immediately recognized the weapon in their lap band or their waistband. I immediately recognized the waistband. I recovered it, right? Then later found out that they were a convicted felon, right? So with that being said, you have to build your cases up, right? But the things to take away from this, guys, are that you put yourself in the perspective of everybody involved. And it's tough, right? Because again, a split second. But you can always slow things down on the streets, right? There's ways to slow things down, right? You got to be safe first and foremost. And the safety of all the citizens that you're dealing with and your safety are paramount. But slow things down and be reasonable. Don't be too slow, though, right? Don't get out thought and don't get hurt, right? Manly, I don't mind you losing because you're going to lose every once in a while. These dope boys are sharp, right? And they know what they're doing, right? You're going to lose every once in a while, but don't lose your life trying to be slick, right? So with that being said, I am going to stick it. That location alone of a high crime area is not grounds for particularized and reasonable suspicion, but also officers are not required to ignore relevant characteristics of a location in question. So does that mean that in my narrative of my report that I don't mention that it's a high crime area, it's an open air market for crack cocaine, and that several individuals like in the last couple of weeks have been stopped with weapons on them, concealed, convicted felons, yada, yada, yada? No, you don't have to ignore the characteristics of a neighborhood, but we don't just automatically assume that everybody in a high crime area is a criminal because it's not true, right? And it's not constitutional to think that way, right? So we see, guys, it went back and forth a whole lot, right? And we're talking about these are judges and attorneys that study this stuff. They had a hard time making a decision on this because it's really hard to scientifically say, oh, that was suspicious. This was suspicious, right? It's subjective, right? Meaning that it's going to be opinion based. And what I see as suspicious might be different than what you see suspicious. But all police officers should be working off of one playbook, and that's the Constitution, right? And their case law, their precedent, right? And if they can't articulate their actions, then they need to stop, right, what they're doing and go somewhere and get in a book so that they can, right? If you can't articulate your actions, you will get yourself in trouble on this job, guys. Make sure you can always articulate your actions. So we picked it. We sticked it. We're going to move on. Check me out, guys, at SOSprep.com, SOSprep.com. Go get the free guided notes, 17 pages of free guided notes. If you want a subscription service, check me out. I can help you out. It helped a lot of people pass this test. Took a lot of anxiety away, and I enjoy doing so. Hit me up if you have any questions, guys. Don't forget to like, comment, subscribe, all that happy hogwash. It helps this stuff get out. Share it with your classmates. And let me know if you need any help with anything, any suggestions on videos. I'll put them out. All right. Thanks, guys. Have a good one. SOSprep.com. Travis Britt out.